Thank you for your arguments, counsel. All right, the court will call the next case, which is Kevin Clark versus U.S. Bank, etc. Counsel can proceed when you're ready.
George Jingo for Mr. Clark. Could they please the court?
I'm sorry, counsel, I could.
George Jingo for Mr. Clark. I would like to take 10 minutes, Your Honor, and reserve the rest.
I have you at 5 minutes for rebuttal. Is that what you wanted?
That's fine.
All right, sir.
Thank you. Your Honor, in a residential foreclosure case, standing is proved under Florida Statute 673.3011. Subsection 1 is as a holder. Subsection 2 is a non-holder with possession and the rights of a holder. And subsection 3 is if there's a lost note, they bring that count. In this particular case, the lawsuit was filed on January 26, 2012. In the complaint, there was no stated statutory basis for standing. Paragraph 3 of the complaint stated that they were entitled to enforce the note via an assignment of mortgage. The assignment of mortgage assigned the note and the mortgage to an entity called the Leader Mortgage Corporation. That assignment occurred on December 7th of 1999. There was no note attached to the complaint. There were also missing from that 2 merger letters, which we'd expect. The first merger letter would be from the Leader Mortgage Corporation to the Leader Mortgage Company, LLC, and the second one would be from the Leader Mortgage Company, LLC to U.S. Bank. 9 months later, this action was amended. That would be October 25th of 2012. And in the amended complaint at paragraph 9, the plaintiff now alleged an entitlement to enforce the note as a holder under Florida Statute 673.3011, subsection 1. This time they attached a note. It had 2 endorsements. The first was in blank, one was in blank and undated. That's the second endorsement. The first endorsement was proper. The second one was blank and undated. Mr. Clark filed an answer, and he denied standing as his second affirmative defense. When this matter went to trial, there were 2 issues that seemed prevalent to us. One is that the court appeared to shift the burden of proof of standing to Mr. Clark. The second was that Plaintiff's Exhibit 5, it's contended by Mr. Clark, did not demonstrate standing. In reading the answer from the appellee, it appears clear that they concede that the bank must prove standing, which now narrows down the issues of this case really to one issue, and that issue is whether Plaintiff's Exhibit 5 proved standing. Plaintiff's Exhibit 5 is found on page 824 of the record, and it states that it's a record from the Secretary of State of Ohio, and it very clearly indicates, I, Jennifer Bruner, do hereby certify I am the duly elected, qualified, and present acting Secretary of State for the State of Ohio, and as such have custody of the records of Ohio and foreign business entities. That such records show the merger of the Leader Mortgage Company, LLC, and Ohio Limited Liability Company, registration number 104-962-9642, registered on December 17, 1993, merging into U.S. Bank National Association. A National Association was filed in this office on June 1, 2004. The bottom right, she states, witness my hand and the seal of the Secretary of State at Columbus, Ohio, this 12th day of June, AD 2008. That's 4 years later. What this document does is it says it's referring to hearsay records. It says that there are records in the office and that this person is looking at those records. So clearly this is a hearsay document. This document does not state that this particular note was one of the items that was transferred in any such merger. It does not state that the mortgage was any such document transferred in the merger. The witness from the bank did not testify that this note and mortgage were actually transferred by this merger. She did not testify that U.S. Bank had actually purchased the assets. There was no testimony that U.S. Bank owned the note and mortgage on a certain date. There was no testimony that U.S. Bank possessed the note on the date the action was filed. There was no testimony of how or when Exhibit 5 came into U.S. Bank's records. And there was no foundation laid for this document under 8036 or under 90211. There were a number of objections that I had made during the trial. I raised those particular objections. The court denied those objections and entered this document into evidence. The court did question what evidence U.S. Bank possessed on the date the action was filed. There was no response from plaintiff's counsel at that time. She couldn't say really what evidence it was that they had that would show that this note was in their possession on the date the action was filed. What's important is in the Ellsman case, which is cited in the documents, is that a crucial element in every case is standing. And it's the plaintiff that has the burden of proof that by substantial competent evidence. In the McLean case, at 79 Southern 3rd, 170, 173, a 4th District 2012 case, it says, plaintiff must show that it held the note at the time the complaint was filed. In the Friedel case, 4D 15, 1750, out of the 4th on May 24th, 2017, no note attached to the complaint, no presumption of standing. In the Green case, which came out of this court, 109 Southern 3rd, 1285, 1288, in 2013, this court said, notice of filing an original note establishes possession and right to enforce it at that time. So there's no presumption of standing in this particular case. In the reply brief, what I stated was in the case of Fiorto versus J.P. Morgan Chase Bank at 174 Southern 3rd, 519, a 4th District case at 2015, at page 521, the court said, merger does not prove possession of a note. There must be additional testimony of when the bank became the owner of the note or testimony that the bank acquired all the assets of the prior bank. In the Ellsman case, the loan transfer history pointing to the PSA did not equate to standing. In another case, the Schmidt case, which came out of this court, identified in the initial brief, a loan purchase agreement did not equate with standing. And in the Perez versus Deutsche Bank case, a 4th District case in 2015, 174 Southern 3rd, 489, page 490, a note in a trust did not equate to standing. This document, this Plaintiff's Exhibit 5, is a summary conclusion of a record. We don't know what record it's a record of. It doesn't state that it's true and correct as a representation of any record. It's pure hearsay and hearsay. And thus, it should not have been the basis for Judge Davidson to say that standing existed in this particular case. In the answer, plaintiff said, or excuse me, the bank indicates that, hey, look, this case originally went to an initial appeal. The final judgment was granted for them. It went to an appeal. This court sent jurisdiction back to the lower court. Then that was set aside because the judgment was set aside and a new complaint was filed. And they say, that's like starting all over. No, that's not like starting all over. In the La France versus U.S. Bank N.A. case, 141 Southern 3rd, 754, at page 756, the 4th DCA in 2014 said, lack of standing at the inception of the case cannot be later cured. They couldn't cure it by filing an amended complaint. They're stuck with what they have. They had no standing in this particular case. They didn't prove it. Submitted.
All right, thank you, sir.
Good afternoon, Your Honors. May it please the Court, I am Brandon Vesley from the law firm of Albertelli Law, and I'm here on behalf of U.S. Bank National. First, I'd like to point out that this case has been going on since 2012. The default date in this case was July 1st, 2011. Mr. Clark has not made a payment in over 6 years now. Your Honors, a couple of facts that he pointed out sort of at the end, but I think that he really didn't hone in on. This case did go to judgment in 2014. It was the appellee, and so they filed a appeal, but before the appeal manifested itself, we asked the court, the appellee here, asked the court to relinquish jurisdiction to the trial court, and then we asked the court to set aside that judgment because we had not included a party that was an indispensable party to the case. So we were the ones that set it aside. But we actually had a judgment back in 2014. Our argument, one of our arguments on appeal, is that by virtue of the fact that we have a new case, essentially a new case, because we had already won and we had to set aside that judgment, we had the option at that point, because we were still within the statute of limitations, to either file a new case or to amend our complaint. We filed an amended complaint, and one of our arguments is that this is not a situation where we didn't have standing and we were trying to create standing by filing an amended complaint. The amended complaint was exactly the same, but this time we didn't forget to attach the note like was done in the first instance. So that note, the same note that's been filed all along in this case, filed as an original document, it's never changed, it's always been the exact same note with the same endorsements, identical, was filed with the amended complaint in 2014. So on that basis alone, we feel like we have proved standing because we could have filed a new complaint. It would be prejudicial to us to say, well, you filed an amended complaint instead of a new complaint, so therefore what you did wasn't sufficient.
Generally, correcting a deficiency in an amended complaint isn't sufficient in the mortgage foreclosure context, is it?
I completely agree, but this
What makes this different?
It's a unique scenario, Your Honor, because first of all, we weren't trying, we actually went to judgment on the first complaint. We actually had a judgment. We set it aside. We were at the position where we could have either filed a new case and named the party that was an indispensable party, was MERS, Mortgage Electronic Registration Systems. We could have filed a new complaint and brought them in under that, or we could have filed an amended complaint, which we did. So we
This
basically
could have happened in any of those amended complaint cases, right? Anytime an amended complaint was filed, the plaintiff would have had the option to file a new lawsuit if they had chosen to. But
Your
the
Honor,
case law indicates that if they choose to go with an amended complaint, it doesn't cure the deficiency, right?
But we were not trying to fix the allegations in the complaint. This wasn't a situation where we didn't say we had standing and now we do have standing. It wasn't something that we went out and we secured the note after the fact. We had the note all along. We just, for whatever the reason, the original plaintiff's attorney neglected to attach it. And he's wrong that we did not say we had we not only had the note, we had the mortgage which was attached. There was an assignment of the mortgage. Everything, all of these factors fit together quite nicely to establish standing. We have a lot of facts that are on our side, and there's very little facts on his side, except for the fact that
If we don't accept your argument about the amended complaint starting the case over again,
Okay, well, let's
are
move.
you able to establish that you established standing as of the time your original suit was filed back on January 26th of 12?
Absolutely, because you're not required to attach a note necessarily. That is one way of establishing standing. You can also establish it through competent substantial evidence outside of that. And our evidence is quite extensive, Your Honor. First of all, we have the fact that we filed the original complaint as a verified complaint. We mentioned in the complaint that we believed we had the note. We had the mortgage and the note, and we were trying to enforce them. We attached the mortgage, which does exactly what we said it did. There was an assignment of mortgage to the leader mortgage company. There was an allegation in the complaint that we were the successor entity of a merger between the leader mortgage company and U.S. Bank National. We have that. Then we move forward, and we have, when we filed the original note, actually we filed a copy of the original note in 2012, about 9 months after the complaint was filed. So somebody along the way must have recognized that they didn't attach it, and they filed a copy of it. Then we filed the original, which matched identically to the copy that was the copy that was filed. The note itself, if you look at it, has evidence that it was originally from the Delwood Corporation, the original lender, was then transferred by assignment, special endorsement to the Leader Mortgage Company. Special endorsement dated the same date as the original lender. So they, obviously the company that made the original loan just did the loan and they transferred it away the same day to the Leader Mortgage Company. That is the same endorsements that were on it when we filed the original, and 2 years later. And then the first trial took place and resulted in a judgment. And then we have so we filed the amended complaint with the same note and mortgage attached. Then they went to trial in this case, and then we have testimony from the representative of U.S. Bank National, who had an opportunity to review all the records through the boarding process, who identified the merger, said that there was a merger between what at that point was in 1999, the Leader Mortgage Company was the holder of the note, and there was a merger in 2004 between the Leader Mortgage Company and U.S. Bank National. So, and the merger is a merger of one entity into another entity, and I cited to a U.S. Code provision that says that when two banks merge in that nature, that all of the assets of the one bank become all of the assets of the other bank. So it would be contrary to that code, U.S. Code provision, for us to have to identify every particular piece of every note or mortgage that gets transferred with the merger. So that's 12 U.S.C. Section 215A, parentheses E. All rights and interests of the individual merging banks in and to every type of property and chose as an action shall be transferred to and vested in the receiving association by virtue of merger without any deed or other transfer. And then that's cited in the Amtone case, where the court wrote, in a merger, two corporations in essence united to a single corporate existence. That's at 182 Southern 3rd, 804. So, Your Honors, we have on our side of the scales, we have the original complaint had the mortgage attached. We didn't have the note, we had the mortgage. It was properly assigned to our predecessor, which was the Leader Mortgage Company. We then presented documentation that there was a merger between the Leader Mortgage Company and the present appellee, in this case, the plaintiff. We also have the note that was filed 9 months later, and we have the original note that matches identically with the note that was filed 9 months after the original complaint. We have the testimony of the representative that the records reflect this merger, and that those records, the note and the mortgage, are actually in the files of U.S. Bank National. So we have a lot of evidence. It may not be direct evidence, it's circumstantial evidence, but when you add it together and you compare it to their side of the scales, which is basically there was no note attached, they don't provide any information about any other, any evidence of anything other than there wasn't a note attached. The scales tip very strongly in our favor. And it is a preponderance of the evidence when the court is weighing, and that's why he tried to argue that the court shifted the burden to, was just asking him, what do you have? Other than the fact that the note wasn't attached, and that's all he had. So regarding the merger document, the court properly accepted it and moved and allowed it to be admitted into evidence under the self-authentication statute 90.9021, we also argued in our brief the court was incorrect in accepting it under that provision. The court could have taken judicial notice of it under 90.202, Either way, the mortgage document should come in, and, was a complete merger. It was from one corporation into another corporation. So we feel that there's evidence there that all of the assets were transferred, especially under the U.S. Code provision. Any other questions?
All right, thank you, sir.
Thank you for your time.
Yes, sir.
Your Honors, in Walsh versus Bank of New York Mellon, it was a case out of this court, 5D15-1898, April 21 of 2017. The court made a distinction of when their copy of the note attached to the complaint is unendorsed and a copy of the note attached to the amended complaint is endorsed, there must be more proof of standing. In this case, there was just no note altogether.
Well, can you fill that gap with testimony as
Sure you
opposed to
can.
documentary evidence?
Absolutely.
And was that done in this case?
No, it was not done in this case. And counsel is missing part of the boat. There were two mergers. They only introduced evidence of one. There's the Leader Mortgage Company, and then there's the Leader Mortgage Corporation, LLC. And the merger document that they were attempting to introduce was that one, the LLC. And in the record at page 902, I had introduced a document from the state of Ohio that says consent for use of similar names, showing there's a Leader Mortgage Company, and that Leader Mortgage Company LLC gives consent to that other entity to use its name. There were two entities. They should have had two merger documents introduced into evidence. They didn't have the other one. My document was admitted into evidence in my case, and it's in the record at page 52, line 7 through 10. So they missed both pieces of evidence they should have entered into evidence, but critically, there was none of that testimony that the witness simply could have laid the foundation by saying, we bought this loan on this date and we acquired that note on this date. They'd have won, the case would be over. They didn't do that.